Welcome back. I hope everyone's geared up for our last session, Hot Debate, moderated by AIAC's very own Abinash Barik. Abinash Barik is a senior international case counsel at the AIAC and a member of the AIAC YPG Maritime Arbitration Core Committee. Mr. Barik is an Indian qualified disputes practitioner since 2014 and has worked in various jurisdictions such as India, the United Kingdom, and Germany at Magic Circle law firms and elite chambers. Presently, he is admitted as a doctoral student at Julius Maximilians Universität of Würzburg, Germany. Floor is yours, Abinash.
Thank you, Kartini. Hello, everyone. We welcome you to the hot debate today. To briefly introduce the two debaters, firstly, we have Ms. Victoria Jureto Kigen. She is a Kenyan licensed attorney with over 6 years experience in dispute resolution and is currently a case counsel at the Nairobi Centre for International Arbitration, NCIA. Victoria is also responsible for handling NCIA administered proceedings, and she is involved in cutting-edge international arbitration projects which are driven by the African Arbitration Academy, among other arbitral institutions and investment regimes in Africa. The second debater for today is Mr. Wesley Pang. Wesley is a partner in the Global Litigation and Dispute Management Group at Eversheds Sutherland. He is based in Hong Kong, where he leads the international arbitration practice. Wesley has over a decade experience in advising private and foreign and sovereign clients on commercial investor-state disputes under various institutional rules. So for the debate today, the debate in motion, Victoria Kigen for this House believes that arbitral institutions should adopt a far more hands-off approach when determining procedural challenges in arbitration proceedings, as these are matters best left with the arbitral tribunal. We have Wesley Pang for this House believes that arbitration institutions shall guard the integrity of the proceedings and ensure efficiency through procedural compliance and decisions in the event where procedural challenges are raised. So in this debate, the way we will move forward is both the debaters will have opening statements. We will then follow up with phase one of the debate, after which they each will have a rebuttal and sur-rebuttal, followed by phase two of the debate, followed by each having a rebuttal and sur-rebuttal. And lastly, we'll conclude with the debate on the phase three. And after that, there'll be a quick closing statement, and then we will invite voting from the participants. So with that, I invite opening statements. And now I ask Victoria Kigen for her opening statement. Victoria? Victoria, can you hear us? I think we're having some connection error. So while we wait for Victoria to join in, can I ask Wesley? Wesley, can you move forward with your opening statement if you're fine with it?
I'm fine with that, Abinash.
Yeah.
And hopefully I won't receive any objections procedurally from Victoria proceeding in this way. So I'm very honored to be here today to be addressing this motion. I'm also very grateful for the invitation to participate in this hot debate by the AIAC in relation to the YPG conference. I'm also very excited by those participating in the moot competition as well, and also those who participated earlier on in this wonderful conference. So as Abinash said, my motion for which I'm arguing in front of is that this House believes that arbitral institutions shall guard the integrity of the proceedings and ensure efficiency through procedural compliance and decisions in the event where procedural challenges are raised. I think what's key is that institutional arbitration over the years has had many detractors across the board. And if I were to rely on or refer to some of the musings of the late Professor Emmanuel Gaillard, He certainly at some point questioned in his celebrated text, Fouchard, Gayad, and Goldman in 1999, that there is in some way a sacrifice that is being made in the name of efficiency, as set forth in this motion. However, the greater efficiency of this form of arbitration, i.e. institutional enforcement, arbitration, is gained at the expense of a certain weakening of the relationship of trust which the parties and the arbitrators are supposed to share, obviously sort of leaning on that rubric or matrix of social actors in the process of arbitration. He also went on to say that the founders of newer institutions, now we are talking about back in the late 1990s, do not necessarily have extensive experience of international business and arbitration, which definitely questions the role to which arbitral institutions can play, and whether or not parties and tribunals are in a way owning up to institutional arbitration and the implications that may have in terms of the dynamic that exists between parties and the arbitrators. That may have been a view necessarily shared by many in the community 30 years ago. However, not many can deny the exponential growth in the number of arbitral institutions around the world and the increasing number of cases moving from ad hoc proceedings to arbitrations administered by institutions under their own rules, or the Untitled Arbitration rules. I think if we were to look at some stats, at least from regional arbitral institutions or global institutions, if I were to take the Hong Kong International Arbitration Center, for example, back in 2015, so not too long ago, it reported administered cases on its docket somewhere around just over 100. So about 116 cases were necessarily administered by the HKSC going back 7 years ago. However, in its latest stats, you'll find that in the 221 stats, that number is ticked up closer to 200 cases that are being administered by the HKSC, somewhere around 180 plus cases. So you can see there has been a growth in having cases administered. And if we were to look at the NCIA, that's the Mumbai Center for International Arbitration, they also recorded a banner year in terms of the number of cases that were administered under the NCIA rules. I think if I remember correctly, that number doubled from the year before to this year in the latest stats reporting. So we can see not only has there been a proliferation in the number of institutions, we also see an expansion in the use of administered arbitration by parties in arbitration. So I think that that's in a way a barometer or a testament to institutional arbitration. Even this growth was recognized by Professor Gayad himself many years in his 2014 Freshwoods lecture titled The Sociology of International Arbitration. So as many may be familiar with that lecture, which was then published in 2016 as a paper, Emmanuel had identified different social actors. So Emmanuel had started first with his aspects of philosophy, international arbitration, and then moved on to sort of the sociology of international arbitration, identified what he regarded as social actors within the community of arbitration. And within that community, apart from essential actors, which are the parties and the tribunal members themselves, there's also the service providers. And among the service providers of the social actors are arbitral institutions. And there's a recognition in his paper or his lecture of also the growth of international and regional arbitral institutions across the spectrum. So I think that what's also important to note from the motion for which I'm supporting is that arbitral institutions are they're not static organizations in themselves. They are ever evolving and innovating, which can be evident from the sophistication of their governing bodies, their governing structures, the composition of the secretariat. I'm not talking about, for example, Abinash is a member of the AIAC secretariat. And then also sort of revisions to the rules. I think many will see the proliferation of institutional rules over the years, whether it be the AIAC, the HKSC, the Icc, so forth. The iterations go far are almost, I wouldn't want to say they're changing annually, but they are certainly changing at a pace that requires every couple of years of refreshing. And I think that that's also quite important to note, that because what we find when there is a rules revision process, with many, certainly with many of the international arbitral institutions, we also witness a consultation process associated with that revision process. And I think that that's also quite important as a part of the evolution of the role of arbitral institutions, but also in terms of the innovation to which they bring to the community and the practice of international arbitration. And to take some examples, and we'll talk about some of these as Victoria and I progress and conduct this debate. But I think that we're also quite familiar with some of the new aspects that we are now finding in institutional rules that have evolved over time, including, for example, the introduction of more mechanisms to deal with multi-party and multi-contract disputes, mechanisms to deal with expedited or fast-track arbitration. You can find that not only in the rules of institutions like the Icc or the HKSC, but you also find similar types of mechanisms in the NCIA, as well as the AIAC, because that is something.
Wesley, would you be able to soon conclude the opening statements?
I'm almost there. I knew you were looking at me in that way, Abinash. I could feel it in your eyes. Just to come to my point. So I think that's quite important, and I think that it's also on this point of evolution. I think that that the fact that they're not static organization means that the guardians of integrity and also sort of the ensuring efficiency is part and parcel with the fact that they are innovative organizations that evolve over time to meet the needs of the parties for which that are acting in their cases. With that, I will hand back to our moderator and conduct.
Thank you, Wesley. So Victoria, you now have 4 minutes to do your opening statements.
Thank you, Abinash. Sorry for the earlier drop off, but I thank you for taking it up. So as had been said earlier, I will argue on the motion that the House believes that arbitral institutions should adopt a far more hands-on approach when determining procedural challenges in arbitration proceedings, as this are matters best left with arbitral tribunals. So when discussing my aspect, then I will have to mention a little bit about ad hoc arbitration, because ad hoc arbitration is more a hands-off approach in itself, as I will mention in my next discussions. So from the medieval times, arbitration has been used as a means of dispute resolution, albeit majorly conducted ad hoc in those times. So what then does ad hoc arbitration generally refer to? Ad hoc arbitration refers to arbitration where parties and the arbitrator conduct the arbitration according to the procedures which will either be agreed by the parties or in default agreement laid down by the arbitral tribunal at the preliminary meeting once the arbitration has begun. However, there are different set of rules available for parties who contemplate arbitration, including the rules of their own trade association. Today, arbitration is very popular in commercial disputes and can be majorly found in commercial contracts. Institutional arbitration has seen the uptake of arbitration in the recent times. So then I would want to explain to you then what does institutional arbitration refer to. It just generally refers to the administration of arbitration by an institution in accordance with its rules of procedure. So many arbitration institutions have their own rules of procedure, while some are modeled under the UNCITRAL model law, some with amendments to cater for each region, each of their regions. So these institutions provide for the appointment of arbitrators, case management services, including oversight of the arbitral process, venue for holding hearings, escrow accounts for arbitral costs, among others. It is, however, noteworthy that with the many arbitral institutions globally, they do not provide the same kind of services. Some simply offer a set of rules and guidelines and no other arbitral services. I could give association among other institutions. Other institutions provide rules and a roster of qualified arbitrators, but are not arbitrators. Then an example will be the Society of Maritime Arbitrators based in New York. Other groups supervise the whole arbitration process from the pre-constitution of the arbitral tribunal, the arbitration life of the final award. An example will be the International Court of Arbitration of the International Chamber of Commerce, among other institutions. For example, I could say the Nairobi Centre for International Arbitration. So institutional arbitration has over the years proved to be more advantageous than ad hoc arbitration, but each has its pros and cons that I would not be able to mention in this discussion. So the question has always remained whether this institution should adopt a more hands-off approach when determining procedural challenges in arbitration proceedings, as this matter should be left with the tribunal, a contention which I will seek to argue in this debate. So my argument will be anchored on three principles of international arbitration. Number one, party autonomy, which basically means the party has the power to design the procedure of arbitration. I'll argue that a hands-off approach will ensure a total party autonomy in an arbitration. Number two, confidentiality. The question now remains whether the arbitration is confidential, where arbitral institutions take hands-on approach of the arbitration. This question will be discussed while we continue discussing these motions before us. Number three, the doctrine of competence. The arbitral tribunal has been established, which is empowered by an arbitral clause. The sole judge of the competence and limitation of the tribunal is the tribunal itself. Now, with that, I've just given a brief background of my arguments, and then I will rest on my introduction. Thank you so much.
Thank you, Victoria. So to begin with phase one of the debate, Victoria, what I will invite you to do is to provide your position on arbitral institutions should adopt a far more hands-off approach when we are looking at the stage of the arbitral lifeline where procedural steps are involved prior to the constitution of the arbitral tribunal. So you have 5 minutes. So could you now proceed with your submissions?
Thank you so much. I will now discuss on the procedural steps prior to the constitution of an arbitral tribunal, as Mr. Abinash has mentioned, and why arbitral institutions should take a hands-off approach during this stage. My first point, while arbitral institutions are deemed as arbitral gatekeepers, their authority should be one of a hands-off approach. That is my major point here. Party autonomy requires the parties freely enter into the arbitral process that is guided by their desires and wishes. This is not to say that the tribunal has no powers, but that their authority is limited to the consent of the parties. Let me give you an example. An example of the NCIA, Nairobi Centre for International Arbitration rules, which I'm quite conversant with and have evidence backing my arguments, where upon registering a request for arbitration, parties are given a chance to select an arbitrator of their choice within 30 days. And then the last repose for appointment is the Nairobi Centre for International Arbitration if the parties have not agreed. From my personal experience, parties generally agree on arbitrator or arbitrators during that period. And we have seen minimal challenges to the jurisdiction of an arbitrator. Whereas in those instances where the centers has appointed, despite the cases eventually proceeding to the conclusion and an award issued, we have seen challenge on the jurisdiction of an arbitrator. Challenge of an arbitrator's jurisdiction may yet be another lengthy process that delays an arbitration, which has always been preached to be a timely one. Therefore, a hands-off approach is essential to uphold party autonomy. To my second point, while most institutional arbitration rules, particularly those that administer the whole process, act as intermediary when it comes to communication between the parties, parties are mostly required to serve the other party anyway, even without these institutions existing.
Victoria, we are not able to hear you. I understand that Ms. Victoria is disconnected, so we'll wait for her to be reconnected. While she's reconnecting, Wesley, can I ask you, for the position that she has already taken, on hands-on approach to guard integrity of the proceedings and ensuring efficiency, why is it necessary, especially at this stage, where it is procedural steps prior to the constitution of the arbitral tribunal?
I think my response draws not only from the submissions made by Victoria just before the technical difficulty, but also in relation to the submissions she made during her opening statement. And I think one operative aspect of both those sort of submissions is that they require the tribunal to be constituted. So I do not contest any aspect in relation to sort of when the tribunal is constituted necessarily. But I think what's important is that you get to the point where the tribunal has been constituted, whereby then their jurisdiction as the tribunal can move forward. However, as many will appreciate, both in terms of acting as counsel or in the role of an institution observing the constitution process, will be aware of many of the aspects in which a party may seek to throw up obstacles to that constitution. I think we also have to be mindful of the consensual process to which arbitration functions. And there are various ways in which that process can be stymied by either a recalcitrant respondent party that's being dragged into the arbitration necessarily, but also by a non-participating party. And I think in this regard, there's two things to sort of take note, whereby the institution plays a crucial role in relation to the arbitral process. And also to call upon, again, from the musings of Professor Emmanuel Gaillard, he accepts, even in 1999, that the involvement of an institution in the application of its rules undoubtedly help in constituting the arbitral tribunal, because although the parties retain a role in that process, everything is geared to ensure that they cannot obstruct it. And I think that's a very key point before we can have that handoff, that the parties are reliant on the institution to move the process forward to constitution. And I think that when you have ad hoc proceedings, you can see how it's quite possible for one side to stymie the process without a third party organization to intervene where necessary to allow for the arbitration to proceed. I think there's also an important part in relation to the gatekeeping that institutions play prior to the constitution of the tribunal. This relates to some of the powers that institutions have in relation to prima facie competency to proceed in a proceeding. Because an institution, certainly an administered arbitration, will receive, for example, a notice or a request for arbitration, and will do a first check either at the level of the secretariat or the level of the court or governing council or governing body to evaluate whether or not the application of the rules or this arbitration has properly been commenced. And in this regard, that's quite critical in weeding out what may be, for example, pathological arbitration clauses, to take one example, or the improper application of particular rules to a proceeding. And that is usually weeded out or brought to the attention of the parties, at least in the first instance, by institutions receiving these requests for arbitration or notices of arbitration. So I think that's quite important. This also leads me to other aspects relating to this, is that institutions also safeguard the notification and communication between the parties before the constitution of the tribunal. And while this may seem more perfunctory or logistical or administrative in terms of the role of the institution, but I think we should not forget the importance when it comes to safeguarding the soundness of an award at the end of the day, because what's important for many of us is that an award can be enforceable, because that's one of the bedrock principles of this whole process of international arbitration. And well, lest we not forget that in relation to the UNTITLE model law, for example, or jurisdictions that have adopted largely the model law, as well as Chapter 5 of the New York Convention in relation to the enforcement of foreign awards, that one of the key aspects of that is that a party must be made aware of or should be notified within the course of the proceedings of the existence of the arbitration. I mean, that's usually one of the first things that gets challenged, or in terms of enforceability or in terms of a set-aside application. I think that's also the other aspect is in relation to the constitution of the tribunal itself, that the parties are aware that the tribunal is being constituted and or the appointment of an arbitrator, especially when you're dealing with a default appointment by the institution, because otherwise the award itself can then becomes vulnerable to attack at the enforcement stage or after it's been rendered. And I think that that's where institutions play a key role at the very beginning before the tribunal is constituted. Otherwise, there could be a question as to sort of how parties are to proceed, especially when you either have recalcitrant respondent party or non-participating respondent party. With that, I see that Victoria is back online. So I'm in your hands, Abinash, as to how you want to proceed from here.
Thank you, Wesley. Victoria, if I may ask you to conclude your thoughts on the first position. We lost you.
Yeah, thank you. I'm so sorry about that. I hope you'll not lose me again.
No worries.
But
and in case you want to immediately rebut Wesley also, you can do that right now.
Yes, actually, I wanted to make a rebut on actually a point on the need of institutions to, sieve out pathological application processes or misinterpretation on joining, on having institutional rules to apply to a particular case. Then I would want to mention that even if the parties, yes, indeed had a contract, and the contract maybe was not really rightfully interpreted to mean that it would be had by an institution, the parties can freely agree again and do and issue an addendum on the same and be bound by the rules of that institution. So that should not be really an issue. So that is something that I wanted to mention on that aspect. And on the last 2 points that I had, that I wanted to mention on institutional arbitration, particularly when it comes to, non-participating parties to join the arbitration process. So while institutional decisions on application on expedited procedures, such as expedited procedures or joinders or consolidation, may be well placed for decision by an institution, parties' autonomy is paramount. And I think this is something that Wesley has also mentioned. And this party autonomy will always govern this proceeding. So a party who feels like, for example, they're forced into the arbitration, joining a third party who was not even intending to be in the arbitration process through, for example, the joinder process by an institution, they may not appreciate the process as they did not consensually decide to join the dispute in the first place. So therefore, a hands-on approach makes this decision look judicial rather than consensual between the parties. This is not one of the major reasoning behind the arbitral process. So that would be an argument that if an arbitral institution would force someone to join, then it would not meet the aspect of party autonomy. Now, then on to my last point. A hands-off institutional approach allows the parties to decide on the conflict of interest aspect. And I think Wesley has just mentioned this, particularly when it comes to selection of an arbitrator. So when appointing an arbitrator, such as an arbitrator who's appointed has indeed passed all the checks and balances that are being, the measures that the parties have put in place when it comes, or rather institutions are put in place when it comes to the appointment of an arbitrator. It doesn't need to go through the laborious process of back and forth communication between the institution and each party. And I think I've seen that a lot when it comes to appointment process, and it takes a long time. For example, here at NCIA, when the parties now have not agreed, then we have to go through the communication between the parties, issue a list of probably 3 names, and would they be able to choose that arbitrator or give us the list of priority. And then it also enforces us to communicate with these potential arbitrators to ask them if we have this case before us between this party A and party B. Do you have any particular aspects of conflict of interest? Whereas if the parties would have had the chance to just select that would even take a day if they had that choice. But now having to go through, the proper checks and balances offered by an institution, the proper checks and balances of making sure that these potential arbitrators are able to join the party without any conflict, because we are not aware, we don't even know the parties themselves, but the parties, they know that the arbitrators, whether they have conflict or not. So I think a hands-off institutional approach when it comes to the appointment should be upheld, as it has always been upheld by these arbitral institutions. That would be my argument. And
thank you,
possibly a
Victoria.
rebuttal.
Thank you. Before we move on, Wesley, any quick rebuttals, 30 seconds?
Just very quickly on the last point in relation to sort of the placing it on perhaps maybe quite squarely on the shoulders of the tribunal or potential arbitrators before they're constituted, especially when it comes to conflict of interest potential. I think that I think, as we've also may have seen through institutions, they also play a pretty critical role in that respect as well too, because many institutions, and this may also be regarded in some ways of the knowledge base of an institution, but also the soft power that an institution plays in relation to the arbitral process, because in this regard, the institutions themselves have a much broader vantage point across a lot of proceedings on their docket, and also the role and sitting of various arbitrators. And that gives them a vantage point as to whether or not, for example, in the confirmation of an arbitrator process, for example, whether it be the ICC or the SIAC or the HKSC, for example, whereby they may then also can raise questions because they may also know that a certain arbitrator is sitting in perhaps maybe 18 to 20 cases at the same time. That's a question of sort of de facto availability. And then there's also the question of, in terms of whether or not there's any issue in terms of conflicts, as Victoria sort of pointed out, because they'll also be aware of parties and other arbitrators that are sitting in those cases. And this may also be an opportunity to flag, for example, reference to the IBA guidelines on conflict of interest to the relevant sort of arbitrator who's subject to confirmation by the institution. So I thought on this point that there is, again, it's the safeguarding the process that an institution can play, and also sort of the broader role that an institution plays behind the scenes. And this is my reference to soft power. Obviously happy to sort of expand on this, but mine's only a rebuttal to Victoria's rebuttal. So I'll leave it there. Thank you.
Spot on, Wesley. So moving to the second phase of the debate. So now I invite Victoria to provide why institutions should take a far more hands-on approach during the arbitral lifeline at the stage after the constitution of the arbitral tribunal. Victoria, the floor is yours.
Thank you, Abinash. Then I'll go straight to my points, right? My first point. Now, while acknowledging different procedures in the constitution of an arbitral tribunal, such as those provided by International Arbitration rules, LCIA, ICC, CRCICA, among others, it is noteworthy that these rules give the first chance of appointment or nomination to the parties. I think I've just mentioned this in my previous discussion, but I'm going deeply on it. So the question is now how far an institution should go into the appointment process. Now, with respect to party autonomy, I have given examples in my introduction on the LMAA and the SMA. Have spared no chance at this. Statistics of appointment of arbitrators under the LMMA, which is the London Maritime Arbitration Association, since 1986, show that many arbitrators have been appointed without the assistance of these institutions. It is only when the parties so agree or cannot agree on an arbitrator as both the LMAA and the SMA appoint an arbitrator. Truly, therefore, most arbitral institutions concur with the fact that the appointment or nomination process should be hands-off and be left to the parties as being the final repose of appointment. Let me just give you a few of the statistics. I'm just going to select from the table they have shared. Now, when it comes to appointment by the London Maritime Arbitration Association, then you can find there are more than the thousands. Like in 1983, you see 4,500 arbitrators appointed. And then in 1996, you see 2,996, 1990, 3,300. So you can see even when these institutions are not participating in the appointment processes, we still see a lot of arbitrators being appointed, which means that the parties themselves already are able to do this without the much assistance of the institutions. On to my second point. When it comes to the challenge of arbitrators, it is also to no contention that the doctrine of competence, which is universally recognized in all developed legal systems, international arbitration conventions, legal scholars' writings, judicial decisions, arbitral institution rules, among others, should apply. Most arbitral institution rules succinctly provide for this doctrine, such as the Exit Convention, Institutional Model Law, among others. And I will give an example of Article 16.3 of the Institutional Model Law, which provides that if the arbitral tribunal rules are as a preliminary question that it has jurisdiction, any party may request within 30 days, after having received notice of that ruling, the court specified in Article 6 to decide the matter, which decision shall be subject to no appeal. While such a request is pending, the arbitral tribunal may continue the arbitral proceeding and make an award. And this was actually has actually been decided in many cases, but I will just give a particular case that I have in mind, the Singapore High Court in the case of Malini Ventura versus Knight Capital in 2015, where the High Court confirmed that an arbitral tribunal has the power to rule on its own jurisdiction, including where a party claims it has not signed any arbitration agreement. So while there's a possibility that parties may not be satisfied with the decision of an arbitral tribunal on its jurisdiction, then the next point of recourse of appeal is the courts and not the arbitral institution. In the Malini case, the court found that so long as a party who is seeking to enforce an arbitration agreement can show on a prima facie basis that such an agreement exists, any question as to the jurisdiction should be first remitted to the arbitral tribunal for an initial decision. If it is necessary for the Singapore courts to consider any questions as to the jurisdiction, then in the normal course, this should only happen after the tribunal has first had the opportunity to rule on such question itself. Therefore, as I have illustrated, when it comes to the constitution of an arbitral tribunal, it is evident in both practice and institutional procedural rules that arbitral institutions have already adopted a hands-off approach when determining procedural challenges on matters, for example, arbitrator appointment and the jurisdiction of a tribunal. And so it should remain that way. Thank you for now.
Thank you, Victoria. Wesley, can I invite you to say why arbitral institutions must have a more hands-on approach, especially when it comes after the constitution of the arbitral tribunal?
That's a good question. I think that one area really depends on the mechanisms that are employed by the rules that they are being applied to the proceedings. And I think that in certain respects, I would point to, for example, where you have potentially two arbitrations that are subject to consolidation. Now, not every institutional rule provides for constitution after the constitution of the tribunal, but there are some rules that do provide for that. And in that process, there then becomes a question because you may have asymmetric tribunals or tribunals that don't necessarily contain the same members of the tribunal, in which case it may be difficult or it may behoove one of the tribunals to move forward on its jurisdiction where the other tribunal is not of the same composition and not able to obviously move at the same pace. So then there's a question as to sort of who can then, how should then the parties be able to proceed in such a scenario, especially when you're trying to consolidate the proceedings. In this case, and I'm pointing to Article 28 of the HKSC rules, that power on the Constitutional Tribunal then gets reserved to the institution. And that's where the institution can exercise its right or competency under the rules to actually wipe the slate clean in terms of both tribunals and actually directly appoint the consolidated tribunal to avoid any issues that may arise if you have asymmetric tribunals. So that's an example of where an institution can come in to play a role after the constitution of the tribunal, but before the rendering of the award, if I were to use an example. I think that another point that I just want to slightly touch upon to what Victoria said in relation to sort of the need to go from the tribunal in the first instance, and if not, then to turn to the courts. And I presume in some respects, we're looking at the courts of the seat, for example. I think in that respect, I think that in certain jurisdictions, we will find that institutions also still play a role in that part as well. So if we looked at if we go to sort of our bedrock principles in relation to the courts of the seat have various roles they can play in support of an arbitration, whether that's granting of interim relief or provisional relief. But then there's also in terms of sometimes the default appointment of a tribunal. If there isn't an institution in place, you actually have to go to the courts to intervene for that process. But I think we also should find that some jurisdictions have actually statutorily reserved that institution. So if I take, for example, in Hong Kong, the actual default statutory body under Hong Kong's arbitration ordinance or arbitration law is actually the HKAC. So in another way, institutions do also play a role in that statutory function or quasi-statutory function when you are in an ad hoc proceeding and you have to rely on a third party to intervene with the Constitutional Tribunal. So this doesn't detract from what Victoria is saying in relation to the importance of the constitution of the tribunal and the tribunal in its jurisdiction and competence. But again, as I was saying before, you kind of have to get to the constitution of the tribunal. And if there's an issue with, for example, replacing an arbitrator on a tribunal, and if you don't have an institution, in some cases you are turning back to institution both in their statutory function rather than their function as just an administrating body.
Thank you, Wesley. On that, Victoria, you have 30 seconds for any quick rebuttal.
Yes, thank you very much. I think mine would be on the aspect of conciliation of arbitration. This is just one little bit of, the whole arbitral process. So if you want to say that we should have a hands-on approach actually institutions should have an hands-on approach, then this would not be the only limitation. This is an exceptional case, and either way, you can give the powers to the tribunals actually to decide on which case to be consolidated with another. Thank you very much.
Thank you, Victoria. Wesley, any other rebuttals? 30 seconds.
I do. Hopefully I can do in 30 seconds. I think that the point here is if I've got a tribunal comprised of A, B, and C in the first tribunal, and I'm trying to consolidate that with the tribunal where I only have A and B and possibly E in the second arbitration, and I'm trying to consolidate that, you still run into the issue as to sort of who actually gets to decide to be the tribunal in the consolidated proceeding, and who ultimately should be able to decide whether or not to consolidate, because each tribunal should be able to decide on its own jurisdiction, and each tribunal should be able to, in its own right, arising from each arbitration agreement, should be able to proceed. But as we now understand, when you consolidate, for example, you are taking two proceedings and bringing them together. So somebody is going to not have a role anymore, whether it's the arbitrator E, because he or she happens to be the outlier among the two tribunals, that somehow is a way that may deprive a party of maybe their nomination. And I'm not referring back to, or not to go back, because we've already had that presentation earlier today in terms of the Dutco case coming from the Cour de Cassation in Paris in 1992. But part of that is also going back to that party autonomy point, and it can be brought to light when trying to consolidate in a non-institutional context. I hope that's 30 seconds, Abinash.
Thank you, Wesley. Moving to the last part of the debate. Victoria, why do you think arbitral institutions should adopt a far more hands-off approach at the stage of conclusion of the proceedings and issuance of the final award? You have 4 minutes.
Thank you so much, Abinash. Now, arbitration must come to an end, and the end product is usually a final award. So institutional rules usually provide guidelines on the timelines which award should be issued. For example, I'm just going to give an example of the NCIA rules, which I'm very familiar with. They require an arbitrator to issue his award within 90 days from the close of the hearing. Now, I have seen most institutions using the hands-on approach by following on the deadline. This is where I would agree with my counterpart, but only to this extent. The issue comes about when it comes to the scrutiny of awards. So certain arbitral institutions like the International Chamber of Commerce and the International Court of Arbitration of the ICC in Paris scrutinize an award before it is published to the parties. The issue is, how far should this scrutiny go? I'm just going to pose questions that would, banter your minds. Will the arbitral institutions be entering into the arena of an arbitrator? Does this result in the ousting of the jurisdiction of an arbitrator? And should this scrutiny be only limited to typographical changes or, when it comes numerical issues, calculations and stuff, but not to the merits of the dispute? Then those are some of the questions that probably you should think about, and as I keep presenting, may be answered or may not be answered. So let me just speak majorly on the ICC scrutiny, because that is one of the institutions that have come up with particular rules that cater for this. So the ICC scrutiny goes to ensuring that the reasoning and content of the award deal with all claims and counterclaims made by the parties, and that the principles of due process have been adhered to throughout the course of the proceedings. Now the question that I would want to pose again, is in this level of scrutiny going too far? If it's going to telling the arbitrator, oh, you have not done this, you should have done this, then does it oust the jurisdiction? Does it oust the powers of the tribunal? So this unique ICC review procedure is often still underrated. Statistics have shown that. Let me just give you an example. There was a survey that was carried out in 2010 by Queen Mary and White and Case, and where only 33% of all surveyed respondents mentioned scrutiny of the award by institutions when being asked that what attracts them to a particular arbitral institution. It so seems that a majority of arbitral institution users are not attracted to these aspects of the award issuance process by that study that was carried out. There could have been more studies, but this study is the one that we can refer to at this point. Now, the validity of ICC court scrutiny of draft awards has been challenged in the past. It has been argued that in scrutinizing awards, the ICC court unduly interferes with the arbitrator's liberty of decision. It violates secrecy of the deliberations and deprives the parties of due process, as they are not included in the exchange between the ICC court and the arbitral tribunal with respect to the draft awards. Some have also argued that by scrutinizing the awards, the ICC court tries to take the place of a state court in the second degree. Also, most arbitral institutions have not taken the ICC and the ICC court approach on matters scrutiny of awards. For example, just give an example of the Nairobi Centre rules. They're actually silent on the need of scrutiny by the Centre. There have been no instances of challenge of an arbitral award so far when it comes to the review. We've only seen minimal changes, which would be on the correction of awards. And the correction of awards which are catered by our rules are just based on the following: computation errors, clerical or typographical errors. So these corrections are usually raised by the parties or the arbitral tribunal on its own motion. This is also another quite evident hands-off approach by an institution, for example, the NCIA I've just mentioned. So yet again, these arguments I've just mentioned, they confirm that arbitral institutions should keep taking a hands-off approach when determining procedural challenges in arbitration proceedings. And these matters should generally be left with the arbitral tribunal and the parties themselves. Thank you.
Thank you, Victoria. Wesley, why should institutions have a more hands-on approach at the conclusion of proceedings and especially at the stage of issuance of the final award? 4 minutes.
The first thing I would say, which is very key, certainly from the perspective of users of arbitration, and I think many of us will be familiar with this, is needing predictability as to when they will receive a decision, i.e. an award in their case. And I think what we now see through the introduction of new mechanisms in institutional roles, and also the role of institutions at the conclusion of the proceedings phase, we find that parties are owning up to the introduction of time limits for the release of the award. If I were to take the ICC rules or the rules of other institutions, we now see institutions in their rules placing more predictability on when they should see an award from a tribunal following the conclusion of the proceedings. And I think with the introduction by the ICC, a necessary, potentially necessary, how do I put this? Penalty in relation to the remuneration of the tribunal and arbitrators for failing to meet the time limits for the rendering of the award is an indication that parties want greater predictability and they don't want there to be any issues as to when they're supposed to find out when their case is going to be decided. So I think that's a key factor in relation to sort of the role that institutions can play. Another role that I think that's also quite important is the growth and maturation of those who sit as arbitrators as a broader community is also engendered by the scrutiny process. So this is going to some of the points raised by Victoria in relation to should there be scrutiny of arbitral awards. I think that when you have a well-trodden arbitrator or tribunal in your case, speaking to Victoria's points, and I think that in those situations, I can see where the necessarily scrutiny may have less of a role to play in that regard. However, as we all know as a community, that younger or less experienced arbitrators or candidates who begin to sit in cases may not have the level of experience in this regard. However, there isn't necessarily a body or organization to which they can turn to necessarily for guidance on their award. And we do not want those type of members or arbitrators to be discouraged from sitting or taking up their first appointment, because then we sort of then lose the evolution and growth and diversification of those who sit as arbitrator. And we also end up maybe with a vicious cycle in not being able to have new blood come into the community as arbitrators, because there's either concern that they may not be able to render awards that are sound and can be enforceable, or we constantly have to rely on those who are the more stalwarts of the community and the bar, the arbitration bar, to sit as arbitrator. Because the court, in the case of the ICC, when they scrutinize, can pick up things like jurisdiction or any issues that may be considered on substance, at least to flag it to the tribunal's attention for them to consider in the scrutiny process. And that of itself can also be quite helpful for younger or young arbitrators who are taking out their first appointment, to have at least someone to review or to give them guidance on their award before it is rendered. I think the other thing that's also sort of mindful, and it's also something that Victoria picked up on as well, which goes to party autonomy, in fact, actually, is you don't have to choose institution and institutional rules that have scrutiny. You are free to choose in your arbitration agreement on an institution that doesn't have scrutiny. As Victoria pointed out, there are institutions that have it and there are institutions that don't have it. So in that part, parties are able to exercise their autonomy at the negotiating phase and the drafting phase to actually just not choose, because the application of scrutiny is actually not across the board. As I said, some major institutions have it, but some don't. So I think that that's also an ability. And arbitrators are also free not to accept appointments in cases where there is scrutiny of their award if they don't want to. So I think that that's the flexibility that we all look to in arbitration in practice.
Thank you, Wesley. Victoria, any quick rebuttals? 30 seconds.
Yeah, just a quick one on the need for scrutiny particularly when it comes to awards issued by younger arbitrators. I seem to agree with Wesley on this, but only on the aspect of scrutinizing particular awards, not for everybody, because you see these experienced arbitrators who have actually been in the field for a very long time, and most of the councils or other people who scrutinize these awards are probably counsels that you would find in an institutions, and they would not really have much experience as you would compare to the arbitrators who have been in the field for a while. So maybe my suggestion would be then the particular rules to cater for younger and arbitrators, so that to encourage them to take up arbitration cases and to scrutinize their awards so that they can be able to grow, but not scrutinizing every aspect of a final arbitral award. Thank you very much.
Wesley, 30 seconds. Any rebuttals?
Not really a rebuttal, but I think that's an interesting point, and that's something that maybe institutions can consider in relation to those who actually apply the scrutiny process.
Excellent, Wesley. Now that we've come to the end of the third phase of the debate and we have 5 minutes remaining, I invite both of you to deliver your closing statements under 2 minutes, please. First, Victoria.
Thank you, Abinash. Mine will be short and sweet, hopefully. So my arguments have shown, and I hope I have been able to convince you, the viewer and the participant, that arbitral institutions should take a hands-off approach when it comes to the administration of disputes. I could not reiterate more on the essence of the major principles of international arbitration, which include party autonomy, confidentiality, and the doctrine of competence, which was what I have been referring to throughout my presentation or my arguments. So while arbitral institutions have been great gatekeepers for the recent years in international arbitration, their supervisory authority should not stifle the basic rights of parties in any arbitral process. Otherwise, it will be similar to the court process, which international arbitration's mission was meant to avoid in the first place. In my introduction, I mentioned that most commonly used feature of arbitration from the medieval times was ad hoc arbitration. This is not to say that arbitral institutions have not played such a great role in streamlining the practice of international arbitration. But to preserve the essence of the process, an amalgamation of ad hoc arbitration practice doctrines and institutional arbitration practice doctrines should be considered by the current arbitral institutions to ensure a win-win for both these institutions and the parties. This will definitely support my motion that arbitral institutions should adopt a firmer hands-off approach when determining procedural challenges in arbitration proceedings, as these are matters best to be left with the arbitral tribunal. In our rest, and I thank you so much.
Thank you, Victoria. Wesley, closing statements under 2 minutes.
I will try to be shorter. I don't know if I'll be sweeter in terms of my concluding statements. I think that we've had many good exchanges between Victoria and I, but I think that one thing that I want to conclude on is what's expected of institutions these days from both arbitrators, counsel, and users of arbitration. And I think that there is a great deal of attention placed on the role that an institution can play in the arbitral process. And in that regard, I think in of itself cements or demonstrates the importance and role to which institutions can play in terms of guarding the integrity of the proceedings, as well as the efficiency through the procedural process. To step beyond talking about time and cost efficiency that can be employed and introduced through the mechanisms of institutional rules, which themselves, as we should not forget, are actually the spearheaded by the institution themselves, not just the administration, but also the genesis and innovation they bring through the rules. But I think stepping beyond just the four corners of that, I think we also see institutions as drivers of social change. And I think that we look to institutions not only for what they can bring to the parties in an immediate case, but I think we are now calling on institutions more broadly in terms of diversity. So there have been a lot of calls on institutions in relation to gender diversity, not only to produce the statistics related to the appointment of arbitrators to show the gender diversity or lack thereof, but also in terms of their exercise of appointment of arbitrators and whether diversity, not just gender, but otherwise, is being employed in that process. And I think that there are also very new or very recent initiatives that also are the remit or the attention being brought on institutions. For example, now We also have the Green Arbitration Pledge, which is a pledge within the space of what we call climate change and ESG to take into consideration. And there's a lot of focus on whether institutions will also sign up to this pledge. And in fact, a lot of them have. And I think there are other aspects of not only just sort of the nuts and bolts role that institution plays, but also sort of the broader change that they can bring about through their role in the arbitral process. So I think that there's more to be seen and there's more to be expected. Thank you.
Thank you, Wesley. And it's 9 p.m. And this is where we come to the close of the debate. Thank you, everyone. And now may I invite our IT team to put up the voting. I invite all the 98, 99 attendees to click on your position. So we have now 1 minute more, between 1 and 2 minutes, where you can start voting. And as you can see, we are seeing the results. So keep voting. We have exactly between 1 and 2 minutes, and we'll get to know which motion proceeds. And while we're waiting for the results, I think it was an extraordinary session. I think the way it was done, I hope as moderator, I had a more hands-off as well as hands-on approach as and when need be to ensure we are efficient, but at the same time, we get to the end of the debate. But excellent position, Victoria and Wesley.
Thank you.
Thank you, Abinash. You are excellent too.
So we are still getting the votes in. I can see 104 attendees. We've got 54 votes. We need the rest of you to vote. Right, so the way it is Wesley, you're still on a rising trend at 64%. We have 40 people left from the 105 attendees. The ones who have not yet voted, we request you to kindly vote. "30 seconds remaining on the voting. "10 seconds remaining on the voting. So the poll has ended. We had 70 out of 111, 63% participated. And the result is 63% are for Wesley, that this House believes that the arbitrary institution shall guard the integrity of the proceedings and ensure efficiency through procedural compliance and decisions during procedural challenges. And 37% believe that arbitral institutions should adopt a far more hands-off approach. And with that statistics, we come to the end of the hot debate. Thank you, everyone, for joining us. Over to you, Kartini.
I hope that was an enjoyable session for all of you. We have now come to the end of our sessions, and we'll have the closing remarks by the co-chair of the AIAC YPG, Lim Tse Wei. Tse Wei is an associate in Herbert Smith Freehill's dispute resolution practice. He has acted in arbitrations under major arbitral rules seated in Europe, Middle East, North Africa, and Asia across a wide range of sectors, including engineering, infrastructure, energy, petrochemicals, telecommunications, and shareholders' disputes. Tse Wei possesses working experience with public international law and international commercial disputes under civil and common law systems. He's also a fellow of the Chartered Institute of Arbitrators and regularly contributes to international publications on arbitration and construction law. He also serves as the co-chair of the Asian International Arbitration Centre Young Practitioners Group and sits on the AIAC Standard Form Contracts Expert Advisory Committee. Floor is yours, Tse Wei.
Thank you, Kartini. And before I begin, I just have to say that's an example of an interventionist institution there, Abinash. Well, thank you, everyone, and good evening. And I'm also very happy to wish many of you a very good morning and a very good afternoon. Thank you for joining us from across the world, from what I've seen in the attendance list over here. And as the co-chair of the AIAC YPG, I am truly delighted by the sheer global footprint of this conference. Also immensely grateful for today's very fruitful discussions of what are clearly very important topics on the constantly evolving landscape of international arbitration. And assessed together, today's discussions remind us that there is room for arbitration to grow. And I'm glad that this message comes about in this Young Practitioners Conference because it truly highlights the importance of young practitioners to global thought leadership in a very fast-moving ADR world. And it's for this reason that we at the AIAC YPG are currently working on new projects that will invite you to challenge the current thinking and orthodoxy of ADR and to innovate new solutions. We will be launching over the next few months the AIAC YPG essay competition and a continuation of our very well-received AIAC YPG podcast series. And these will all cover very topical issues in investment arbitration, commercial arbitration, general issues like ADR, mediation, negotiation, you have it. Please do catch us on Spotify. We will also be soon growing our global footprint together with our maiden cohort of AIAC YPG regional representatives, one of whom you've seen today in our second panel. And this will aim to allow the AIAC YPG to collaborate with ADR thought leaders in different regions across the world to bring you even better content and even wider spectrum of perspectives. So please do watch this space. And we hope that you found our upcoming events as engaging as today's conference. And on behalf of my colleagues at the AIAC YPG, I extend a big thank you to all for gracing us with your presence at this conference today, and to all participants in the pre-moot this week. We wish you the very best of luck. In the meantime, keep safe wherever you are. Thank you. Back to you, Katrin.
Thank you, Tse Wei. This brings us to the end of the YPG conference. Thank you all very much for joining us, and I hope all of you had an enjoyable and fruitful time today.